Thank you all for being here for this course with Professor Lars Vinx. Some people may not know who are watching online that we had, for this year long, we had a cycle of lectures about Hans Kelsen, the science and the politics of law. And this was an idea by Nicolas Costa, who is not here, but I thank Nicolas for this idea of this cycle of lectures that will generate a book that we are editing for next year. And I also thank Rodrigo Marchetti, who is author of this Bible about Kelsen and Schmidt.
Bible, really.
The best introduction to Kelsen and Schmidt in Brazil. And this was the inspiration for this cycle of lectures. And in the beginning of the year, I met Professor Lars Vinx at Cambridge, and I invited him to be with us. I thought he would not agree with that idea, but he is here, and this is a priceless opportunity to have you here, Lars. And I also would like to thank Daniela Diaz, who will be here soon, for helping welcome you here in São Paulo during these 2 weeks. And Professor Vinx is one of the main global scholars in jurisprudence today. He's the author of a book called Hans Kelsen's Pure Theory of Law, Legality and Legitimacy, published by Oxford in 2007. And he's the author of 2 important volumes. One, The Guardian of the Constitution, Hans Kelsen and Carl Schmitt on the Limits of Constitutional Law. That will be the subject of his lectures next week, the debate between Kelsen and Schmitt about the Guardian of the Constitution. And he also edited this book, Carl Schmitt's Early Theoretical Writings, published in 2021 by Cambridge. So it's the best way to close this year of studies about Kelsen with this main author, specialist in both Hart and Kelsen today, who is Professor Lars Vinx. So thank you, Lars, for all these 5 lectures during these 2 weeks, and the floor is yours, please.
Yes, so thank you very much, Lucas, for both for the invitation to speak here. So I'm very, very happy to be able to give a series of lectures here in Sao Paulo, and thank you for the very kind introduction. So I will give 5 lectures in the course of these 2 weeks, and I've tried to make them all self-contained as far as I can, but I must warn you, today's lecture is a little bit of an introduction or a stage-setting lecture, but I hope it will nevertheless be interesting to you. So the overall topic is Weimar perspectives on the problem of constitutional guardianship, and I'm talking about Hans Kelsen and Carl Schmitt in particular. So we have a number of different balls to juggle, so to speak. So we are trying to address the problem of constitutional guardianship and to think about what a constitution is and what it might mean to protect it against the threats that perhaps democratic constitutions face today. But we're trying to address this topic from an oblique angle, from a historical perspective. So I will start to talk a little bit about the problem of constitutional guardianship in the Weimar Republic. And then, of course, the main topic will be how Hans Kelsen and Carl Schmitt, and I assume you are both somewhat familiar with these 2 authors, how they responded to the problems of constitutional crisis in the Weimar Republic. And so we're going to spend a lot of time comparing their constitutional theories, their legal theories, and their conceptions of constitutional guardianship to hopefully learn something about how a constitution could be guarded today. So the first of these lectures today will focus to some extent on Weimar and will provide historical background. So I will tell you a little bit about a political event in the late Weimar period in 1932 that in German is called the Preußenschlag. So just to explain, Preußen was one of the states of the Weimar Republic. So the Weimar Republic had a federal constitution, just like Brazil, and Preußen was the largest German state at the time, so making up about half of the nation's territory and containing most of its population. And the Preußenschlag was an attempt, as we'll see, by the federal government to gain control over the government of Prussia. And the question was whether this coup, as it has been called by some authors, was constitutional. So I'm going to talk a little bit about this historical event to set the stage. Then we're going to look at Kelsen's and Schmidt's responses to this Preußenschlag, or the strike against Prussia. And then I'm going to close with a few remarks, sketchy remarks on the potential contemporary significance of Schmidt's and Kelsen's responses to the constitutional crisis of the Weimar Republic. Good. So let us begin then to look at the historical background. So here on this picture, you see Paul von Hindenburg, who was the president of the Weimar Republic. And as president of the Weimar Republic, under Article 48 of the Constitution, that we will look at in more detail later in this lecture, he had the power to issue emergency decrees in cases of a threat to public order and security. And so what he did in July 1932 was to issue a decree that transferred the powers of the Prussian government, the government of the state, to the prime minister at the federal level, a man named Franz von Papen. And so the idea was that all the government of Prussia was to be transferred to the federal level, and the federal government would unite the federal government and the Prussian government in its hands. So the decree empowered the prime minister von Papen to take over the competences of the Prussian prime minister, to depose members of the Prussian parliament, and to take over the governance of Prussia. And the decree itself did not indicate any expiry date of this transfer. So it appeared that what was intended was to permanently snuff out the political independence of the state of Prussia and to unite the powers of Prussia and of the federal government in the hands of the federal government. Good. So a little bit further background is necessary to understand what's going on here. So you can see in the slide how Prussia is the largest of the German states. 1932, and in the Weimar Republic, since 1929, there was no longer a functioning parliamentary government. So the Weimar Constitution provided for a parliamentary system of government. The government was appointed by the president, but it had to have the support of the majority of members of parliament. So parliament had power to depose a government by way of a vote of no confidence. And now, at this time, in 1932, there was no longer a governing coalition in parliament. So parliament was divided into a number of different political parties that were unable or unwilling Parliament did not succeed to form a government with the support of a majority of members of parliament. So what happened then is that the president, Hindenburg, appointed a government that was tolerated by some of the parties in parliament. So they did not support it, but they did refrain from unseating it through a vote of no confidence. So the key party here was the Social Democratic Party, center-left party, that decided to tolerate the presidential government by not voting in votes of no confidence against the government. So you had a government that was tolerated by parliament, but that no longer had a parliamentary basis. And the way that this government operated was by appeal to presidential emergency decrees. So they were unable, of course, since they didn't have a majority, to pass laws in parliament. So instead, the laws that they wanted to enact were issued in the form of presidential decrees. And again, Parliament would have had the power, as we will see, to ask for the repeal of a presidential decree. But again, the Social Democratic Party decided to tolerate presidential decrees and not to support motions for the repeal in Parliament. So you have a very strange situation where government no longer functions as it should, but there is still a veneer of constitutionality. Good. Now, Hindenburg himself was a conservative, so he had been one of the generals in the First World War under the previous imperial government, and he and conservative forces around him weren't too unhappy about the fact that parliamentary government had broken down. So they saw this as an opportunity to establish perhaps a presidential government with a very conservative bent on a permanent basis. And in particular, Hindenburg was keen to make himself independent of the toleration of the Social Democratic Party. So he resented the fact that as a conservative, that he was dependent for his government to work on the support of a party of the left. So this takes us then to the project that was pursued in the Preußenschlag. So what happened here is that the Nazi party had been quite successful in the previous election, had become the second strongest party in parliament. There was another election upcoming. It was expected that the Nazis would gain further votes in parliament. And so negotiations were initiated between the president and his government and the Nazis for the Nazis to step into the role of the Social Democratic Party as the party that would tolerate or passively support the presidential government. And so what the Preußenschlag was supposed to do is to provide a kind of payback to the Nazis in order to make them disposed to support the president. So the Prussian government in 1932 was still in the hands of the Social Democratic Party, the SPD. And the government in Prussia was quite concerned about the street violence of the Nazis and had banned Nazi stormtroopers or brown shirts from appearing on the streets and was trying to suppress their violent activity. And so the Nazis were interested in getting out from under this constraint on their actions. And so a plan was hatched for the Nazis to support a presidential government after the next election in return for the restrictions on their activities to be lifted. And to do that, of course, the Preußenschlag was necessary because it would give the federal government, controlled by the president, control of the Prussian police forces. Good. Now, the second aim, of course, in the Preußenschlag was just to get rid of one of the last bastions of the Democratic Party, the Social Democratic Party, at the state level. So the idea was that you could combine the powers of Prussia and the powers of the federal government in one hand and draw on the support of the Nazis. It would be possible to permanently establish a conservative government that was no longer dependent on direct parliamentary support. Good. Now, another piece of history then is that this carefully laid out plan to establish a conservative government, it failed for a number of reasons. And so one reason why it failed was that after the election, which took place just 2 weeks after the Preußenschlag, Hitler's party was so successful that it became the strongest party in parliament. Hitler had won so many members of parliament, though he didn't have an outright majority, that he wanted to be appointed as prime minister by the president, in place of von Papen, who was the president's preferred prime minister. So Hitler was not willing just to give passive toleration to the government. He wanted to be prime minister himself. But at least at that point in August 1932, the president refused to appoint him as prime minister. Now, the second reason why the plan failed was that the Prussian government, though it did not resist the Preußenschlag by forceful means, using its own police force, for example, or challenging the government in the streets, and the Prussian government appealed to the Supreme Court of the Weimar Republic. the Reichsgericht, and contested the constitutionality of the decree by which it had been removed, and by which von Papen, the prime minister at the time, had been given the power of government in Prussia. So I should say a few words about this court before we go on, because that's going to be important in understanding the rest of the narrative. So the Weimar Republic had a Supreme Court. It's called the Reichsgericht, but it did not really have a constitutional court. So the Reichsgericht was just an apex court, a Supreme Court, but the Constitution did not explicitly endow it with the power to review statutes or presidential decrees for their constitutionality. Instead, it contained just one article, Article 19, that gave this Reichsgericht a very, very limited power to act as a constitutional court in conflicts between the federal government and the state. So Article 19 determined that whenever there was a constitutional conflict between the federal government and the government of a state, then one of these two parties could appeal to the Reichsgericht, and the Reichsgericht would then be able to act as a constitutional court only with respect to these federal disputes. Okay? So that was a germ, if you want to put it that way, of constitutional adjudication in the Weimar Republic, but it was not very developed. Still, of course, since this was a conflict between the federal government and the state, the Prussian government was appealed to the Supreme Court and to argue that the decree against Prussia was unconstitutional. And the court indeed took the case and heard it, and that, of course, interfered with the president's plans. Now, the Reichsgericht also then issued a decision fairly quickly. This was in October 1932. And in that decision, as we'll see, the court did not actually reverse the transfer of power from the Prussian government to the federal government, but it nevertheless issued a kind of rebuke to the president and to the federal government in claiming that the decree that the president had issued was, at least in part, unconstitutional. And Hindenburg himself seems to have been quite angry and upset about this, and henceforth he was very concerned to act within the bounds of constitutionality. And as we'll see later, somewhat paradoxically, that helped Hitler to take power in early 1933. Good. So then let us take a little bit of a closer look at the constitutional provision that the president employed in the Preußenschlag. So this is the infamous Article 48 of the Weimar Constitution, which I'm sure many of you have heard about and may be familiar with. So here are the key provisions in this article. So there's a first paragraph that says that if a state does not fulfill its obligations that are imposed upon it by the federal constitution or by the laws of the Reich, so the Reich is the federal state, then the president may make use is usually referred to as the power of Reichsexekution, or federal execution. So the idea is that you have a federal system, the states must abide by the federal constitution and by the laws made at the federal level. And in order to ensure that this happens, the federal government must have a power to compel states to live up to their legal obligations. And here the president is made responsible to do so, perhaps even by the use of armed force. So in fact, the presidents or earlier presidents in the Weimar Republic, Friedrich Ebert, the first president, used this power repeatedly against states and in the early 1920s, and used military force to compel them to abide by the federal constitution. Now, this power is then supplemented by a second, which is usually in scholarly debate in the Weimar discussion as a power of dictatorship. And of course, here dictatorship is to be, or the notion of dictatorship is to be understood with reference to the ancient Roman understanding of dictatorship, right? So it's not doesn't refer to authoritarian rule, but to emergency action for the protection of the Constitution. So here's the paragraph 2. If public security and order are seriously disturbed or endangered in the German Reich, then the president may take measures for their restoration, intervening if need be with the assistance of the armed forces. And then it says, well, for this purpose, he may suspend for a while, in whole or in part, the fundamental rights provided in Articles 14, 15, 17, 18, 23, 24, 53. So these articles are articles like the right against arbitrary arrest, the inviolability of one's house or apartment, the right to protest in public, but also the right to property. So the idea is that there are certain rights that might stand in the way of effective action in a situation of emergency, in a crisis where public security and order are seriously disturbed, and therefore, in order for measures for the restoration of order to be effective, the president must have the power to suspend them. Good. Now, the president, it seems, is the one who decides whether either of these two powers is to be used. But paragraph 3 imposes a limitation on the actions of the president. So the president must inform the Reichstag. The Reichstag is the federal parliament, if he's taking action either under paragraph 1 or under paragraph 2. And the Reichstag can then demand by a majority vote that a presidential emergency decree be revoked or repealed. But of course, as I've pointed out already, in the late Weimar Republic, there was no parliamentary majority that was able to act in order to repeal presidential emergency decrees. So this limitation had fallen away. There was another provision here at the end, paragraph 5, in the Constitution that says that a statute is to be made in order to legally determine in more specific terms how these two powers, the power of Reichsexekution and the power of dictatorship, are to be exercised. And of course, if such a law had ever been made, it might have restricted the president's powers quite significantly. But as it turned out, the Reichstag never got around throughout the Weimar Republic to actually enact that statute. So Article 48 was, in a sense, the sole legal basis of the president's emergency actions and of the Preußenschlag. So quite a rather unbounded transfer of power to the president. So let me make 2 more observations. So one observation is that the scope of the power of dictatorship under Article 48.2 was contested in legal scholarship. There was no agreement exactly about what the president might do or was not permitted to do. But the majority of opinion among scholars held to 2 claims about how to read paragraph 2 of Article 48. So the one claim was that the measures that the president is entitled to take, include the power to enact emergency decrees with statutory force. Okay? So you might argue that the notion of measures should be interpreted narrowly. So Schmidt actually made this argument in 1924 at an earlier stage, where he said that, the president is only given the power here to take measures. And so to take a measure is just to do or to perform some de facto action that is necessary in order to restore public order and security. But the right to take measures for the restoration of public order and security, Schmidt argued, does not include a right to issue legal norms. Okay? So that is not a measure to make a decree that in content is a general law and that is supposed to have statutory force. But presidents in the Weimar Republic often, in situations of crisis, issued emergency decrees that were general legal rules that were claimed to have statutory force, and this practice became established. So the majority opinion of scholars supported it. So it was held that a president can take a decision that really in content is a law in the material sense under paragraph 2 of Article 48. Now, a second question, and again, we will see that Schmidt was a dissident from the majority opinion of scholars in this respect. The second question about Article 48, paragraph 2 is exactly what the suspension clause here entails, how it is to be understood. And so I'm going to talk about how Schmidt reads this later on. So now I'm just going to throw out what the majority of scholars had to say about this, which is also, I think, the intuitively most compelling reading of this paragraph. So the majority opinion of scholars was committed to the view that while the president was able to suspend a certain number of constitutional rights when taking action under this paragraph, so the rights listed here, he had to respect, or he had to abide by all other constitutional provisions in taking measures for the restoration of public order and security. Right? All the provisions of the Constitution not listed here. And so that was called the Unantastbarkeitslehre, or in English, you might translate this as the doctrine of inviolability. And the idea is quite simple. It's to say that though this power here is very broad, it is a power conferred on the president by the Constitution. So one should assume that action that is taken under this article must be constitutional, unless we are talking about one of the articles that can be suspended by the president, and in that case may be violated by the measures the president takes. So the idea is that the Constitution as a whole provides a restraint on the dictatorial action of the president. And we'll see that Schmidt disagreed with this when we come to his views about Article 40. Good. Now, I think with this background, one can offer a preliminary assessment of the constitutionality of the president's decree that transferred the power of government from the state of Prussia to the federal level. And I think that assessment is very straightforward. So it seems quite evident that the Preußenschlag, or the president's decree to transfer power of government from Prussia to the federal level, was not constitutional. Yeah? So if you assume, as the proponents of this doctrine of inviolability do, that the president must abide by all constitutional provisions in taking emergency measures that are not suspendable, then of course all the provisions that concern the status of a state in the federal system still apply and must still be respected. And so, for instance, there was one article, Article 17 in the Weimar Constitution, that guaranteed to each state its own democratically elected government. And of course, the transfer of governmental power by presidential decree from the level of Prussia to the level of the federal state is a violation of this provision, but it's not one of the articles that the president, under Article 48, may suspend and then disregard. There was another provision, Article 63, that was relevant. So in the Weimar constitutional system, apart from a federal parliament, was also a Reichsrat. So this is a federal council, translated into English. And this was a body that was manned by representatives of the governments of the states. And as a body, the Reichsrat had certain veto rights in the federal process of legislation to give the states an opportunity to offer protest, or at least to delay federal statutes that they saw as impinging on their interests. Perhaps a further remark that could be made is about the power of federal execution that I talked about. Implicit in the decree that the president issued that Prussia had violated its legal duties toward on federal execution, but the decree did not name any specific violation of federal law on Prussia's part. So you might think that this appeal was made in bad faith, which further supports the claim, of course, that at first glance, obviously, what the president did was unconstitutional. Good. So now we come to the judgment of the Reichsgericht or the Staatsgerichtshof. So the Staatsgerichtshof was the tribunal formed at the Reichsgericht in cases where a state under Article 19 of the Constitution brought a complaint against the federal government or the other way around. So here is a translation of the judgment that was put forward or issued in October 1932. So it says the decree of the president of the 20th of July for the restoration of public security and order in Prussia, it's compatible with the Constitution of the Reich. Okay, hooray. That sounds good for the president, but now comes a fairly strange qualification. It's compatible with the Constitution insofar as it appoints the Chancellor of the Reich, so Chancellor is the German word for Prime Minister, as Federal Commissioner for Prussia and authorizes him to deprive Prussian ministers temporarily for a limited period of time of their competences of office and to take over these competences himself or to assign them to other persons acting as commissioners of the Reich. Okay. Now, you have a second paragraph then, which says, well, this authorization, however, could not permissibly extend itself to depriving the Prussian Ministry of State and its members of the power to represent the state of Prussia in the Reichstag, in the Federal Council, or else towards the Reich, or of the power to represent the state of Prussia towards the Prussian Parliament. Good. So that's quite a confusing judgment. So in one sense, it says that the decree that the president issued was unconstitutional, right? Because the president intended, and the decree intimated that the powers of the Prussian government were to be permanently taken to the federal level and not just temporarily. And of course, the way that the decree was understood by the president himself and by von Papen was that all the powers of the Prussian government were to be transferred to the Reich, and not just some. And so here, the scope of the decree, according to this judgment, is not fully constitutional because the Prussian government must be preserved for the reason that the Constitution guarantees to every state its own democratically elected government. And that is why the court determined that, well, the federal government can continue to exercise control of the Prussian apparatus of government for the time being in order to restore public security and order. However, the Prussian government must also continue to exist, so it will continue to represent Prussia in the Federal Council and also in the Prussian Parliament. And so suppose the powers of the Prussian government were split in two in the court's judgment, even though the decree that the president issued had intended to take all the powers of the Prussian state to the federal level. So it seems that this is a puzzling judgment. The court ought to have said that the decree was unconstitutional, it seems. So what they're doing instead is to say that, well, it's unconstitutional, but perhaps if it had been phrased in a slightly different way, in a more limited form, it would have been constitutional. And we're just going to pretend or indulge in the fiction that this is how the decree is to be read. So you might say this was an attempt at a Solomonic compromise. Now, I said earlier that the decree was a rebuke to the president, and the rebuke comes more in the judgment itself, in the opinion that is attached to the judgment itself than in the judgment. So let me just fill you in on this very quickly. So in the opinion that's attached to the judgment, some further aspects of the decree are repudiated quite explicitly. So the opinion makes it clear that the court held that the Prussian government hadn't violated any of its legal obligations under the Constitution or under federal laws. And so as a result, the appeal to the first paragraph of Article 48 on the part of the president was misguided or legally insubstantial, invalid. So really, if there is a part of the decree that is constitutional, according to the court's view, it must be the exercise of the power of dictatorship under paragraph 2 of Article 48 that the president also appealed to. But in its judgment, and this is noteworthy, the court affirmed or upheld the doctrine of inviolability that I talked about earlier. So it made explicit the point that if the president takes measures under Article 48, paragraph 2, all the constitutional provisions that aren't suspendable have to be respected. And arguably, of course, the decree doesn't do that. And that is why the court tried to strike the strange compromise to split the powers of the Prussian government in half and to say that for the time being, the federal government can take control of the apparatus of government, but the Prussian government, the elected Prussian government, continues to exist and to exercise certain ceremonial functions, and the arrangement is temporary. So at some point, when emergency action ends, the Prussian government will step back into its normal constitutional role. Now, perhaps one further remark that could be made about this compromise is that the concern that's really guiding this strange attempt to split the difference is a concern about the principle of federalism. So I suppose what the court was inclined to do, or what it intended to do in this judgment, was to support the principle, the constitutional principle of federalism, and to make it clear that the Weimar Republic could not be turned from a federal state into a unitary state by way of an exercise of presidential powers of dictatorship. Still, it seems quite clear or undoubtable that if this was an exercise of constitutional guardianship on the part of the court, it was a failed instance of constitutional guardianship. Okay? And so there are a number of observations, I guess, that can be made to show that, but perhaps the most important is that the judgment didn't protect federalism specifically, or the Weimar Constitution in general, because not very long after, the Nazis did take power, as you all know, in January 1933. And so perhaps I have to explain briefly how that happened in order to substantiate my claim that this was a failed attempt at constitutional guardianship. So the Nazis had become the strongest political party in the federal elections in late July 1932. And as I pointed out earlier, so Hitler wanted to be made prime minister. And he refused to give passive toleration to the presidential government and to the people that the president wanted as ministers and as prime minister. So he bargained for the president to give in to appoint him as prime minister. And he was successful in that because due to the fact that parliament was split, that there was no governing majority, the only way forward, I suppose, for the president to appoint the government that he wanted to appoint, made up of conservative technocrats, would have been to dissolve parliament and to suspend further elections indefinitely. And the president didn't want to do that because it would have been unconstitutional, and the rebuke that he had been issued by the court stung and affected him. And he wanted to play it safe and stay on the road of legality. And so he appointed Hitler prime minister, and Hitler, with the support, of course, of his own party and some conservative parties, then had a parliamentary majority and was able to use the powers of government to establish an authoritarian system and to destroy democracy. And the Preußenschlag played a role in that, because as a result of the Preußenschlag, the control of the Prussian apparatus of government, in particular of its police force, was in the hands now of the federal government. So it was in the hands of Hitler and the ministers he appointed after he had become prime minister. And the powers that were made available in this way to the Nazis, of course, were used from the start of the Nazi period to persecute and to suppress political dissidents. So it wasn't just a failure as an act of constitutional guardianship. Inadvertently, the court's decision facilitated, insofar as it allowed the federal government to keep control for now of the Prussian apparatus of government, facilitated the consolidation of Nazi power. Good. So that was all the history. And now we are coming to the two theoreticians or authors that we will focus on in this series of lectures. Carl Schmitt and Hans Kelsen. And so Schmitt and Kelsen did not agree on many things, but they agreed on one thing, namely that the judgment of the Reichsgericht or the Staatsgerichtshof was indeed a failed attempt to exercise constitutional guardianship. But both Schmitt and Kelsen, of course, had very different reasons for taking this view. And so what I'm going to do next is to talk a little bit about how they responded to the judgment and why they thought it was a failed instance of constitutional guardianship. Good. So here you have a picture of Carl Schmitt in his prime. So this is probably from the late Weimar period. And so perhaps I should say a few words about Carl Schmitt, just by way of introduction. Though I assume that many of you will be familiar with Carl Schmitt to some extent. So Schmitt was a professor of public law who throughout the 1920s had championed a reading of the Constitution that tried to emphasize the political nature of any constitution and of the Weimar Constitution in particular, and who assailed the positivist or formalist reading of the Constitution that was then predominant. Now, politically, he was conservative, but at least in the 1920s, Schmitt was willing to offer, from a conservative point of view, an affirmative interpretation of the Weimar Constitution, the one that differed very starkly from the interpretation that was given by other constitutional scholars. And so we'll delve in the lecture tomorrow into some of the key aspects of Schmitt's understanding of democratic constitutionality. Now, I should also say, of course, that though Schmitt had interesting things to say about how we should understand the democratic constitution, his name, of course, is besmirched or tarnished by the fact that after 1933, Schmitt very quickly decided to throw in his lot with the new regime, the National Socialist regime, and he became one of the key supporters in legal academia of the Nazi regime, and published, especially in the years from 1933 to 1936, a long litany of very ugly and anti-Semitic, anti-liberal articles in support of the actions of Nazi dictatorship. And for that reason, his bona fide as a democratic constitutional theorist is under a shadow, and he has to be read very carefully and critically. because it may be that, of course, his later shift to Nazism is in some sense foreshadowed in or compelled by some of the ideas that he held at an earlier point. But we are going to have the opportunity to say more about this in another lecture. Perhaps a final point I should mention is that Schmidt was involved personally in this in the legal proceedings about the constitutionality of the Preußenschlag in the Reichsgericht. So he was a member of a legal team of 2 or 3 law professors that was to make the case for the president and his government. And though, of course, the court, as we have seen, decided not to reverse the transfer of power, it declared the decree of the president to be unconstitutional in part. And so Schmidt seems to have experienced this as a rebuke, not just to the president, but also to his own views and to his interpretation of the Constitution. And in his writings after 1932, you find repeated attacks on the decision of the Reichsgericht. So Schmidt was clearly very unhappy with it. And so here is an extract from one of Schmidt's writings from the early Nazi period, Staatsgefüge und der Zusammenbruch des Zweiten Reiches, in which Schmidt offers his commentary on the attempt on the part of the Reichsgericht to save the Weimar Constitution. So he says, after the failure of parliamentary government, the breakdown of parliamentary government in the late 1920s, bourgeois constitutionalism, the view he attributes to his jurisprudential opponents, developed by itself into the political submission to the neutrality of apolitical judges, who did not merely refuse to lay claim to political leadership or governmental authority, but who, to the contrary, founded their competence and their right to decide precisely on the fact that they decisively repudiated any claim to political leadership. Thus, bourgeois constitutionalism, thought through to its end with consistency, found its point of culmination where the will to political leadership was at the 0 point. And that was the perfection and crowning of bourgeois constitutionalism. Okay, so what is the challenge here to the court? It's perhaps a slightly unusual challenge given the political context of the present. So the claim here is not that the Constitutional Court was trespassing into the field of politics. So rather, the complaint here seems to be that the Constitutional Court was unable to exercise the kind of political leadership that would have been necessary to save the Weimar Republic. So the judges were cowards in trying to achieve the Solomonic Compromise. And what they did was inadvertently to play into the hands of the Nazis, whose accession to power perhaps might have been prevented by a stronger presidential government. Now, of course, institution that is capable to exercise political leadership and that has the political legitimacy to do so. And as we will see, of course, in discussing Schmidt's views in more detail, he has grave doubts about whether a court could be an institution that has the political legitimacy, the capacities of political leadership to be a successful guardian of the Constitution. So, to put this differently, Schmidt wanted to argue that the president was trying to guard the Constitution in trying to unify the powers of Prussia and the federal government. The president might have stood in the way if he had been successful of the Nazi accession to power. But this possibility was thwarted by the decision of the Reichsgericht. So the Reichsgericht should have stayed out of this business, and perhaps then presidential guardianship might have been more successful. Good. Now, I said that Schmidt was appointed as a legal representative of the federal government. So his interpretation of Article 48.2 explains, I think, why the federal government was thinking of him as a legal representative. So we've seen this text already. So paragraph 2 of Article 48 And so let me say a few words now about how Schmidt understands this. So if public security and order are seriously disturbed within the German Reich, the president may take measures necessary for their restoration, intervening if need be with the assistance of armed forces. And for this purpose, he may suspend for a while in whole or in part the fundamental rights provided in the listed article. So I said earlier, I mean, the intuitive reading to impose on this article is to say that, well, the president is bound to the Constitution, and the only way in which he can become unbound for parts of the Constitution is to suspend some of the articles that paragraph 2 gives him a power to suspend. So focus just on the first sentence of the paragraph for a second, right? So it says that the president of the Reich may take measures necessary for the restoration of public order and security. Okay? It doesn't say what measures the president can take. I guess it only says that the president can take whatever measures he may think are necessary and will be effective for the restoration of public order and security. Okay? Now, in order, second sentence, to restore public order and security, the president may also suspend certain fundamental rights. But this doesn't mean, according to Schmidt, that any other provisions of the Constitution are secure from dictatorial action. So the president can violate constitutional provisions not listed here in this article. Now, the obvious objection to this reading, of course, is to say, well, this seems to make the second sentence that says that certain articles are suspendable superfluous, right? If the president can disregard the whole Constitution in taking measures for the restoration of public order, then why does this article say that, or this paragraph of Article 48, why does it say that some constitutional provisions can be suspended by the president? And so Schmidt's answer to that is to say that the legal effect of the suspension is just to make it so that other organs, other public organs, other organs of state than the president himself and those who act on his behalf are unbound by the suspension from having to respect these constitutional articles. Okay? So I don't know if a paragraph or article 115 is suspended by the president, then the government of Bavaria, which is one of the states of the Weimar Republic, does not have to respect that article. Okay? But when the president himself acts, so those who are directly authorized by him, then all the Constitution is violable or is not a limit to presidential action. Okay? Good. So this is a slightly counterintuitive reading, okay, of this article. And what it does, of course, is to widen the president's powers enormously by doing away with this doctrine of inviolability that I talked about. So the presidential decree clearly would have been constitutional according to this reading of Article 48, because the principle of federalism would not have been a limit to presidential emergency action. Now, Schmidt was, of course, also convinced that the notions of public security and order are not ideas that can be given legal precision. So whether public security and order are gravely disturbed in such a way that measures, unusual emergency measures are required, is a political judgment that can only be taken by a political agent. And under Article 48, the president is made responsible for taking that decision. So the claim is that really, apart from the fact that paragraph 2 allows the president to trespass on the principle of federalism, the Reichsgericht, the court, ought to have refrained from reviewing the president's actions because the court isn't capable to decide or to assess whether emergency measures are indeed necessary. Good. So you can see that the president here in this conception is given a very, very wide range of powers. Now, if the president exercising these powers is to be regarded as a guardian of the Constitution, then the question arises, what exactly does the president guard when he makes use of the powers that Schmidt thinks Article 48.2 gives him? Right? So the president can infringe upon or violate all provisions in the Constitution, perhaps bring about a fundamental rearrangement of political order by putting the powers of the largest state of the Federation into the hands of a federal government. So I guess we'll have to address the question what it might mean to say that the president's powers here are employed for purposes of guardianship. Good. Yes, I think I covered the things that are on this slide already. So let us turn to Kelsen. So Kelsen himself, as you all know, is one of the greatest legal theorists of the 20th century. He's famous for having developed the pure theory of law, which is perhaps the most interesting, the most systematic version of legal positivism. But Kelsen was also a constitutional theorist of some consequence. So Kelsen was not German, though he wrote and published in the German language. He was from Austria. And he had been involved after the First World War in drafting the constitution of the Austrian Republic of 1920. And this was one of the first constitutions that established a specialized constitutional court, endowed with the power to annul statutory norms acted by Parliament. And Kelsen was one of the architects, I guess, of that institution, and he was also a judge on this constitutional court in the 1920s, until he resigned, I think, in 1931, due to a conflict that the Austrian Constitutional Court had with its own government. And Kelsen then left Vienna or left Austria and took up a position in Germany at the University of Cologne, where he was actually a colleague of Schmidt's for a very short period of a few months. But after 1933, after the Nazi seizure of power, Kelsen was removed from his position at the University of Cologne because he was Jewish. And he then fled to Switzerland, to Geneva, and later to the US. But at this point in time, 1932, that we are focusing on, he was in Germany. And though he wasn't, like Schmidt, directly involved in the proceedings at the Reichsgericht, he did publish an article in an academic journal discussing the judgment of the Reichsgericht. And so let me just give you a very, very brief overview of what he says in that judgment. So Kelsen says that the problem with the court's judgment is that it's incoherent for reasons that I've already put forward. So the judgment affirms that the permanent transfer of the Prussian government's powers to the federal level violates the Constitution, but it also claims that there's a more limited decree embedded in the decree that the president issued, a decree whose content is outlined in the judgment, as we've seen, that would have been conformable to the Weimar Constitution. But Kelsen says, well, but this is not the decree that the president issued. The president issued a decree that was attempting to do more than just to temporarily transfer powers of the Prussian government to the federal level. So what the court ought to have done is to annul the president's decree or to declare it unconstitutional. Good. Now, if this is so evident, why didn't the court do that? Why didn't the court just say that the president's decree is unconstitutional and annul or repeal it? Well, Kelsen argues that the court is put in a bind here or in a difficult situation by the fact that the Weimar Constitution contains certain technical deficiencies. So Article 19, under which the Reichsgericht acted as a constitutional court in federal conflicts, it did not endow the Reichsgericht explicitly with a power to annul statutes or presidential decrees. So what it said instead is that a decision taken by the Reichsgericht in such a matter has to be enforced by the president, okay? Which is rather awkward because the president, of course, was or his government was one of the parties to this dispute. And obviously the president himself and his advisors would have argued that this decree was constitutional. So the court was put in a very, very difficult position by the fact that the Constitution had not made sure to give it an explicit power through its own decisions to annul presidential decree. Now, you might get around this, perhaps, Kelsen suggests, by arguing that, well, the decision that's taken here by the Reichsgericht could be regarded as declarative rather than constitutive, as a judgment that merely states the fact that the president's decree is legally null and void because it is unconstitutional, and therefore does not have to be annulled or repealed by the court or by anyone else. But Kelsen thinks that this way around the problem is unavailable here. So whatever you may think about the legality of the decree, it was issued by a duly elected president in the pursuit or in the use of powers conferred upon him by the Constitution. And as a result, Kelsen thinks it doesn't make any sense to argue that the decree could have been null and void from the beginning. So the court's judgment would have had to have been constitutive and not declarative, to offer an authoritative resolution of the dispute on constitutionality that we are faced with. But the court wished to avoid a conflict with the president, of course, and therefore opted for its misguided Solomonic compromise. And so Kelsen says, well, this approach, of course, is not just awkward, it's also unsatisfactory in that the judgment, because it is so unclear in what exactly the court wants the president to do, isn't even executable by the president, even if the president had the will to do so. Good. So, like Schmidt, he concludes there is a failed instance or aspect of constitutional guardianship in the court's decision, but he thinks that the root of the problem is that the Weimar Constitution did not provide for a proper constitutional court and did not endow it with the proper powers of a constitutional court. And if it had done that, then perhaps the court could have taken a decision that would have been legally clearer and more successful in guarding the Constitution. So for Kelsen, what this episode shows is not that a constitutional court can't be a guardian of the Constitution. What it shows is that in order for a constitutional court to act as a guardian of the Constitution must empower it properly and give it the competences it needs to play that role. And because the Weimar Constitution didn't do that, the court wasn't able to reach a decision that might have been helpful in safeguarding the Constitution. So now you have a fundamental contest about constitutional guardianship between Schmidt and Kelsen. So Schmidt will argue that constitutional guardianship should fall with the president, with the executive, whereas Kelsen wants to advocate for a constitutional court as the guardian of the Constitution. And as you can see here, despite the fact that a constitutional court seems to have failed quite obviously in this case to act as a constitutional guardian, both views can still be upheld. So what we're going to do in the lectures to follow is to look in more detail at the arguments that Schmidt and Kelsen offered for these two different views. Now, I should say that the academic debate between Kelsen and Schmidt about who should be the guardian of the Constitution, it precedes this episode in 1932 of the Preußenschlag and the ill-fated intervention of the Reichsgericht. So Kelsen and Schmidt had exchanged academic barbs for a number of years by that point. So the Kelsen-Schmidt debate as an academic debate begins in 1929 with a paper of Kelsen's that's called The Nature and Development of Constitutional Adjudication. So as I said earlier, in the Weimar Republic, there wasn't really a specialized constitutional court, but there was in Austria. And Kelsen, like some other legal scholars, advocated for the introduction of a specialized, separate constitutional court in Germany on the model of Austria. And this paper here, or this talk, was a talk originally of 1929, offers Kelsen's summary of his argument for the introduction, the creation of the Constitution. Now, Schmidt responded to this with a book in 1931 called The Guardian of the Constitution, in which he develops his claim for presidential guardianship, and argues both that the Weimar Constitution actually makes the president the guardian of the Constitution, but also that from a more general theoretical level, the executive is more suited to act as a guardian of the Constitution than a constitutional court. And Kelsen then replied to this in 1931 with a very critical and rebarbative review of Schmidt's book, Who Ought to Be the Guardian of the Constitution, in which he sort of takes Schmidt's argument apart in order to defend the claim that constitutional guardianship should be vested in court. And so we're going to take a look at these texts and this debate next week, but in preparation for reading these texts and contextualizing the arguments contained in them, what I want to do first is to delve a little bit more deeply into Schmidt's and Kelsen's democratic theories and constitutional theories. So tomorrow there'll be a lecture focusing on Schmidt, and then next week, I think on Tuesday, I will say something about Kelsen, and then in the last two lectures next week, we get to the Kelsen-Schmidt debate in the narrow sense, and talk a little bit about how it might relate to contemporary understandings of constitutional guardianship. Good. So let me just close by throwing out a few suggestions that I will try to develop more in the remainder of these lectures about why it might be interesting to look at this historical example of a debate about constitutional guardianship. So is there something we can learn from this Weimar debate on constitutional guardianship? So there's one explanation of the relevance of the Weimar debate that I will not focus on very much, because I don't think it's sound, or that it makes a whole lot of sense, and that is what I call the Radbruch framing. So there's a view that says that, and this was popularized by Gustav Radbruch, a German legal philosopher, immediately after the fall of Nazi dictatorship, that says that the Nazi dictatorship, both in terms of its attempts to take power, but also in how it operated in Nazi Germany, was favored by the prevalent legal theory in Germany at the time, namely legal positivism. And so Radbruch claimed that a positivist takes the view that whatever is enacted by authorities is law and must be respected as such by legal officials. And he argued that this view, this very crude positivist approach to the nature of law, had made people disposed to obey even shockingly unjust decrees issued by the Nazis. It had also made it easier for the Nazis to take power, because a formalist understanding of the Weimar Constitution had helped the Nazis to manipulate constitutional legality, to take power and then to consolidate their rule. And sometimes people argue that, well, Kelsen is someone who, as a positivist, was unable to respond to the challenge of Nazism in a satisfactory way. And so the poverty, or the apoliticalness of Kelsen's views is said to be an instance of the poverty of positivism in face of authoritarianism. And sometimes this view is combined then with the claim that Schmidt, though he later threw in his hat with the Nazis, had an understanding of the Constitution that was more suited, perhaps, to respond to situations of constitutional crisis. And perhaps natural law theories in general are more suited to do so than legal positivist theories. So I think that this framing of the debate between Kelsen and Schmidt is mistaken, both because, as I will argue, Kelsen's views aren't apolitical, and they do have a lot to say about how to respond to challenges to democracy, but also because I think it's historically wrong to argue that positivism was responsible for the seizure of power of the Nazis. So the truth is that most legal positivists were supporters of the constitutional democratic system, and the people like Schmidt who rejected positivism were the people who were willing to support the Nazis, sometimes before they had taken power, but in most instances after as well. Good. I think there's another reason why it's interesting to look at this Weimar debate and the debate between Kelsen and Schmidt in particular, and that is because it can tell us something about democratic constitutionality. It can help us understand the idea of democratic constitutionality more deeply. So here are a few questions. So if we talk about constitutional guardianship, what exactly is the object of protection? What is a constitution? Is it a system of norms, or is it a political condition? And Schmidt and Kelsen, of course, have different views about this. We should also be interested in the question, what makes a constitution democratic, and how the democratic nature of a constitution is related to the idea of constitutional guardianship. And I think that Kelsen and Schmidt, precisely because they offer two very, very different, diametrically opposed answers to this question, are interesting to compare and to look at. And I think what they say, though we will often have reason to be critical of it and to reject it, it helps us to understand these questions about the nature of a constitution and constitutional democracy more deeply. Good. Final slide. So I think a further advantage in looking at this Weimar debate is that it addresses problems of constitutional crisis more directly than a lot of contemporary debate about the legitimacy of constitution. So I guess if you look at the matter from a contemporary point of view, then perhaps your first thought about constitutional guardianship will be that, well, constitutional guardianship is a question about the legitimacy of constitutional review in a democratic polity. So is it justifiable for there to be a constitutional court that interprets constitutional rights and then uses its interpretation of constitutional rights to annul statutes issued by a democratically elected parliament? And of course, many authors think that there's a tension here between this form of the protection of constitutional rights and the principle of democracy. So if you're committed both to liberal rights and to democracy, how can you mitigate or soften this tension? So that is the center of the contemporary debate about constitutional guardianship. But one weakness of that debate is that it starts from the assumption, and you can see this in authors like Walken or Waldron that I will talk about at the end. It starts from the assumption that democracy is not under threat, it's securely established. All political parties, the members of a community, are committed to democracy, and they are also committed to liberal rights, individual rights. And the question then is just, well, if people disagree about exactly what the scope of some constitutional right is, what's the most democratic way to resolve that dispute? But that is, in a sense, a fair weather problem. Okay, it's not the problem that people had in the Weimar Republic. In the Weimar Republic, you have a constitutional system, a democratic constitutional system that is under direct threat from powers that want to destroy democracy. And the question is, how can democracy be preserved in a situation where neither a commitment to liberalism nor a commitment to democracy can be taken for granted? And the interesting thing about the Weimar debate is that, of course, it speaks to these questions because neither Kelsen nor Schmidt were in a position to assume that the constitutional system was securely established. And they also disagreed fundamentally about what it meant to say that it was a democratic constitution. And I suppose these issues are only becoming more relevant day by day. And I hope that our detour into these slightly dusty historical authors is going to help us to think a little bit harder about constitutional problems in the present. And so thank you very much for your patience, and I hope you will have some questions.
before passing the word to Ricardo, I have a doubt. Because this author, Matheus Tomás, vai ter um lançamento, mais um evento, hoje à noite, 7 da noite, o lançamento desse livro, A História Não Contada da TGE no Brasil. The author of this book about the general theory of state, he endorses an explanation, I think that by Chris Thornhill, that Schmidt supported this arrangement in which the president indicated the chancellor and the parliament did not use the motion of no confidence, this kind of passive acceptance of the chancellor. And I have this doubt if Schmidt really has an argument about this that would be against what is written in the constitution, that the chancellor should be supported by the majority of the parliament. But the arrangement since 1930s was that the parliament did not support it, but did not use the no confidence motion against the president. And he argues that Schmidt has a clear and direct doctrine supporting this idea that the chancellor is just pointed out by the president and does not need the support by the parliament. And is this a justifiable reading? And Schmidt really puts out this doctrine about not having to have the support by the parliament.
Yes, I think the short answer to that is yes. And so Schmidt was, I said, he was involved in the trial in the Reichsgericht, but in this period, the later years of the Weimar Republic, he sort of moonlighted as a kind of legal advisor to the presidential government. But this was done to some extent in a secret, clandestine fashion. So one of the key advisors of the president was a man by the name of Kurt von Schleicher, who was a general, but who was a political general, who was, in a sense, the driving force, I guess, of this attempt to permanently establish the presidential system. And Schmidt was connected to the circle around this man and gave legal advice to the presidential government. But it's difficult to make out exactly what advice he gave because some of the texts that people rely on were never published, and it's not even clear in some cases whether Schmidt is really the author and so on of this or that memorandum that one finds in some archives. But it's clear that he was connected to this group of people around the president who wanted to establish a presidential government and a project to succeed. And I mean, the big problem for this group was that they weren't able to find, so the president didn't want to work with the Social Democrats. But in any case, after the election in July 1932, they had lost a share of members of parliament, and the Nazis were the strongest party. So really, for the project to work, the Nazis would have had to support it, but without Hitler being made prime minister. And so the project just failed because Hitler refused to be drafted into this role. And now there would have been another option that was discussed in the circles around the president, namely just to dissolve parliament and to declare a Staatsnotstand, so an emergency of state, and just to suspend elections indefinitely and to rely on the power of the military to just govern in openly authoritarian fashion. And von Schleicher wanted to do that at the end of the day, but Hindenburg refused to support him in that and appointed Hitler instead because he wanted to steer back to a path of legality. And so where Schmidt stands in this is hard to say. So I think some historians claim that when Schmidt gave advice, he was always cautious to advise against an openly anti-constitutional course. And he was preferring to argue that the presidential governments with passive toleration of parliament were not unconstitutional, given that parliament had failed to create a governing majority. So the argument is that it's constitutional because the constitution itself provides for presidential government as a fallback mode of governance. And I think that is what as far as we can tell, Schmidt wanted to argue for. And so in a sense, the view that you recall from your Brazilian colleague is correct. But I think I would add that it's a further question, really, whether one should speak here of guardianship of the Constitution, because of course the Constitution was meant to be a parliamentary democracy and a project to, in a sense, to disempower Parliament indefinitely perhaps isn't a defense of the Constitution as much as a modification, at least if the project is not a mere emergency measure, but is intended as a permanent mode of governance. So I think we should be critical about the claim that Schmidt's interpretation of the Constitution was altogether defensible. But with that caveat, I think I agree with the assessment.
Thank you, Lars. Before passing the word to Ricardo, we invited I invited the Professor Ricardo Spindola, who was at a postdoc in Max Planck Institute and now is teaching at the Federal University of Tocantins, to comment this lecture by Professor Vinx. But we have two questions from the audience, Ricardo, and then I will pass to your comments. Por favor.
I want to know, like, with this wave of conservatives that we're seeing worldwide nowadays, do you see any similarities in terms of constitutional violation from that period to now?
Well, so I guess we'll have an opportunity to delve more deeply into this, but I guess it seems to me that if there is a connection, then perhaps the connection is that some of the ideological background to contemporary populist political movements is to be found in Schmidt, at least in the sense that there are ideas about democracy that are quite similar to Schmidt. So I think we'll learn something about the ideological basis of authoritarian populism by looking at Schmidt, contrasting him with Kelsen. I mean, on the other hand, so if you're talking about what happened today, it seems, I mean, the difference is that, of course, if say a right-wing political party wins a parliamentary election or a presidential election under the terms of the Constitution, then of course, presumably you should argue that there is no constitutional problem. In the Weimar Republic, of course, the Nazis, even though, of course, their share in the vote grew quite dramatically in the final years of the Weimar Republic, they never won a parliamentary majority. So they were never really in a position to establish themselves as a majority government. And that's why these strange intrigues and shenanigans of which the Preußenschlag is a part were necessary for the Nazis to be able to take power. And so here we have a path to power that was paved by bending and breaking the Constitution, I guess. And I guess the focus of Kelsen's and Schmidt's involvement, at least in today's lecture, is on that process of bending and breaking.
Yes, sir. My question is, here in Brazil, we have an article in our Constitution that is quite similar to the Article 48 of the Weimar Constitution, in the sense that it says that the armed forces have this duty of protecting the constitutional order and the separation of powers, putting this the army in this position of kind of a referee of the constitutional questions. And I see this article as a representation of this legacy of the Brazilian politics, and where the army has this position historically of putting itself above politics as a kind of I don't know how to say, but a kind of referee of politics at all.
Mm-hmm.
And my question is, similarly, this article of the Weimar Constitution can be put as an inheritance of Germany as a country that was born as an absolutist monarchy, a country that had no experience with a liberal democracy. And my question is, can we put this, the Brazilian Constitution has this problem that is a direct legacy of our problems with democracy itself. do you think that this article, I don't know nothing about the Weimar Constitution information, but do you think that this similar?
Yes, I mean, I think Schmidt would have found that article quite to his liking, I imagine. And so we'll see tomorrow that in Schmidt, I mean, the theoretical background to his reading of the Weimar Constitution is the idea that in order for a legal or a constitutional order to function properly, it must rest on a situation of social homogeneity and established social order that is not deeply or fundamentally contested. And he claims that this presupposition of the applicability of legal norms must be guaranteed by a political authority that he calls the sovereign, at least in political theology, in one of his key writings, where he says the sovereign in every state is the institution that has the power to declare a state of emergency that is unbound from any legal or constitutional restraints. And he thinks that any state must have such a sovereign in order for its stability to be guaranteed, but the guarantee can't be given by a legal institution. It must be a political institution with the power to prevail in a situation of crisis where there might be violence or direct contestation of public authority. And so of course, if a constitution points its finger towards an institution that can step into that role, Schmidt would say, well, yes, great. So they recognize that the law is dependent on prior political conditions of normality and that someone must be responsible for securing them. But of course, the flip side of this view then is that the protections that the law affords are always conditional. Right? So they're given only for as long as the person or institution that claims the sovereign role doesn't suspend the law, switch it off. But Schmidt would argue that it's a good thing for a constitution to at least give a hint as to who might play this role. So he would approve of it. But of course, as we'll see, Kelsen would very much argue that a provision like that really is a threat, a grave threat to a democratic order.
Thank you for your lecture, Professor. It was really good. And my question is, nowadays in the Brazilian political scenario, we are seeing a lot of distrust from the general population against the authority of the Supreme Court. At the point that some people regard it as authoritarian and even say that there's kind of a dictatorship of the judicial power. So it's kind of different from the case of the president having too much power. And yeah, it's the contrary situation. And do you think it's possible to have like a state where the constitutional court exercise so much power against the other powers, that it kind of becomes an authoritarian regime by the constitutional court? And what measures can we take against this kind of situation?
And some call it Schmittian, judicial Schmittianism, like the sovereign is the constitutional court.
Well, I think so. As we'll see, I mean, Schmidt has a view of what courts can legitimately do that is very, very narrow, and so I think he would argue that a constitutional court that takes decisions that are deeply controversial politically, and of course that claim to have the power to push aside all the decisions taken by other organs of constitution are problematic because I think on the one hand he's worried, of course, that the court doesn't in the end have the power to guarantee stability, but on the other hand he also thinks that courts shouldn't take political decisions. So that is the narrowness of his concept of adjudication, and he believes that for a constitutional court to take highly contested decisions about the scope of constitutional rights would create problems of legitimacy, that a court in the end cannot shoulder. So I think he would see this this condition or this situation as quite problematic. I mean, Kelsen, of course, is a proponent, a very vigorous proponent of a constitutional court that is formally very, very strong in terms of the powers that it has. But as we see, Kelsen has a conception of democracy that is sort of intriguingly close to some authors, some contemporary authors who are opposed to judicial review, like Jeremy Waldron, for instance. And so I think he tries to combine an emphasis on majoritarianism with an argument for constitutional review, but it's hard to see how this is going to work, because there seems to be a tension between constitutional review and democracy as majority rule. And so I think the way that he tries to mitigate that conflict, Kelsen himself, is to suggest that a court must be very humble and restrained in its interpretation of the Constitution, and that essentially it should focus on protecting the integrity of the democratic process. And it should not make appeal to fundamental principles underlying the Constitution in order to take decisions that are politically contested. But of course, the problem is once you have an institutionally very, very strong constitutional court, you cannot perhaps in the end prevent a court from not being as restrained as Kelsen would like it to be. So it may be that the reconciliation between democracy and constitutional review that he calls for is under stress in Brazil, but elsewhere as well.
Professor Ricardo Espíndola, please.
Yes, thank you very much. I'm honored to comment on Professor Lars Vinx's first lecture. Professor Vinx's editorial and translation efforts were pivotal during my master's, and I had yet to learn German properly, offering me, and so I believe many of you there in São Paulo for the first time, a first-hand account of the more technical and subtle documentation making the bulk of the Kelsen-Schmidt debate. Now, I had the chance in the last years to return to the subject from a completely different point of view, Professor Lucas Q, to reread Professor Vinx's introduction and to hear his take on the constitutional and historical situation informing the debate and its epitome, the notorious case Preußen contra Reich, was truly welcomed. I am prepared 2 remarks deriving 2 questions therefrom. These 2 remarks concern one statement and one absence. Read the statement in David Eisenhower's Legality and Legitimacy, one of the readings Professor Lucas suggests to you. And conversely, one can note the absence I have in mind in Professor Vinx's introduction, but I must add that he addressed this absence in his reply to Professor Lucas, mentioning the crucial name General Kurt von Schleicher. Ultimately, I claim that this statement and this absence speak to important threads undergirding the constitutional situation in these crucial years of the Weimar Republic, informing its constitutional semantics, political structures, and political constellations. Accordingly, scholarship has carefully probed each of them since and in parallel to Eisenhower's and Professor Vinx's appraisals. The 2 questions concern how these results reached by ongoing scholarship qualify our interpretation of the actions and events surrounding, leading to, and following from the judgment in Leipzig. Then to my first remark. Should we turn to Eisenhower's Legality and Legitimacy, read that the formulation Hüter der Verfassung, guardian of the Constitution, was made popular by Carl Schmitt, but my ongoing research, 1 year of which was conducted in the Max Planck Institute for Legal History and Legal Theory, shows that this is false. So first of all, already in July 27, 1922, Friedrich Ebert, in a communication to the Minister-President of Bavaria, so the governor of Bavaria, uses the formula claiming to be the guardian of the Constitution in this struggle where Bavaria challenges the constitutionality of the statute regarding the protection of the Republic. But if Ebert used it already before Schmitt deployment thereof in 1922, it's probably because it dates far back here. And this is it's something that I have been researching so far. And when I came there in São Paulo on Professor Lucas' invitation, I suggested that the first appearance of the term in Germany could be dated to 1843, to Friedrich Murhardt's article on Staatsgerichtsbarkeit in the Staatslexikon edited by Karl von Hotek and Karl Welker. But after returning to Germany and doing some a little more of archive research, I found even earlier entry, and that would be Jakob Green, and he's writing Jakob Green über seine Entlassung from 1837. And why it does matter that in 1837, one of the Green brothers mentioned it. First, because it's one of the Green brothers. Yeah, so this made it usually accessible to everyone. And second, because it's a political writing Jakob Green wrote during the so-called Göttingen Sieben, or the Göttingen Seven, where he explains why he was dismissed from Göttingen University following his and other 6 professors' resistance against this Staatsstreich, this coup d'etat made by then King of Hanover, Ernest August. And there it's the first time where he says, we, the civil servants, the professors, had to take the place of the guardian of the Constitution because the parliament failed to do its job. So this is the earliest entry I could find. From there, it goes to, as I said, Friedrich Murhardt and his article claiming that a constitutional court could exercise this role, but why it wouldn't make sense in Germany in its confederate situation. From that, we have Rudolf von Gneist in the presentation he does in 1863 to the Deutsche Juristentag, where he also claims that the judiciary could exercise this whole role of constitutional guardianship. And finally, and it is somehow related to the question about the German tradition or lack of tradition with democracy. In 1878, Paul Laban, in the 2nd volume of his handbook on state law, says that it's absurd to think that the judge could exercise constitutional guardianship. Only the German constitution, the Bismarck's constitution, acknowledges only one Hüter und Warden der Verfassung, and that is the emperor. So this is the tradition that reaches the Constitutional Assembly in 1918, and most of the arguments and the conceptions available back then say that the emperor was and should continue to be, in whatever fashion, the guardian of the Constitution. And when we have that in mind, and this tradition of saying that ultimately, at least the last 20 years, that the emperor should exercise this office, my first question then is, what does this tell us to the wave that Schmidt's argument had back then? Because as Professor Lars Vinx mentioned in the last slides of his presentation, today, people tend to return to Schmidt and said, well, he was the underdog. And as the underdog, he had a very interesting position because we tend to project our own situation where constitutional adjudication is evident. But from this quick reconstruction I did, one has a sense that in the Weimar context, people like Kels and Triple were the underdogs. Yeah, so this was my first question, whether Professor Vinx agrees with this appraisal of Schmidt's stance in the debate. And to give 2 further evidence of my argument that Schmidt was not the underdog, he was actually defending a majoritarian position in terms of constitutional scholarship during Weimar. The first evidence concerns Gerhard and Schut's commentary on the Weimar Constitution. And as I was doing this research, I went to Gerhard and Schut's leading commentary, as everyone in the scholarship indicates, striving for a remark on constitutional adjudication. And then I went to his comments on the article about the Staatsgerichtshof, and there is nothing there about constitutional adjudication. Instead, he discusses it in his commentary to the power of the president to sign the statutes. Yeah, and there he says, well, there are people who argue that the Staatsgerichtshof should entertain a Nachprüfungsrecht. But as Laban argued, and then he even mentions from 1932 under Schmidt, as Laban and Schmidt argued better, this is something that befalls the president. Yeah, so a leading democratic commentary ultimately acknowledged that nach Prüfungsrecht should is befit to the president and not the Staatsgerichtshof. And the second evidence that I just come across yesterday, as I was reading the stenographic notes on the Parlamentarische Rat, so the Constitutional Assembly that wrote the Grundgesetz between 1948 and 49, it's actually quite funny how its members often refer to the president when they wanted to make sense of what the office of the Guardian of Constitution entailed. So even social democrats like Georg August Zim, when they say, well, we need the Constitutional Court and it must exercise the office of constitutional guardianship. And to my mind, he adds, the sort of attributions that are included therein are the sort of tasks that the president must fulfill. Yeah, so it was so evident that even social democrats who had all the reasons to be against Carl Schmitt reproduced this notion that, at least for the time being, it makes much more sense to think of constitutional guardianship as something proper to the president. So this closes my first remark and first question. My second remark, as I said, concerns General Kurt von Schleicher, and what does it mean to Schmitt be a part of its circle? And this is something that I must emphasize in saying that he was part of this circle. Professor Vinx is much more careful than, for instance, David Deisenhaus. David Deisenhaus says Schmitt was the chief advisor of Kurt von Schleicher, but this is not true. I mean, in this leading monograph, Gabriel Seibert says that Schmitt most probably met von Schleicher only once, and he never met von Papen, supposedly. Yeah, so you cannot be someone's chief advisor, legal advisor, if you met that person only once. That being said, Schmitt was one of the leading advisors of this constitutional division in the Ministry of Defense. And this is something that tells a lot about the role of the military considering constitutional interpretation, namely the fact that they had a division dedicated to constitutional affairs. And my second question concerns this relationship and this close collaboration of Schmitt with the military. One can trace this collaboration to some personal decisions in Schmitt's life. For instance, at the time of the Preußen contra Reich case, Schmitt was not a law professor, strictly saying. He was not in a university. He was actually in a Handelshochschule in Berlin, so a high school for commerce, and he taught there constitutional law. And the main reason why he moved from the University of Bonn, the very prestigious University of Bonn, to the Handelshochschule was first because it was in Berlin. Second, then he could be really close to the circles of power. And third, he could give courses attended by civil and military servants. And this is most probably how he got in touch with the circle around Kurt von Schleicher, because they attended his course and brought him questions. And then, as Professor Vinx says, he gave his opinions in secret fashion to these servants operating under von Schleicher. But how this relates to the debate on constitutional guardianship? Something that has been exciting in my imagination is the fact that when we turn to a previous work of Carl Schmitt that Professor Vinx mentioned, his presentation before the Vereinigung der Deutschen Staatsrechtslehrer about the dictatorship of the president nach Article 48. So after Article 48, there he doesn't use the metaphor, not even once, despite the fact that it makes the perfect sense to use it. And despite the fact that the metaphor was already available. And then why? Yeah, I mean, the answer that I have been thinking about is that at that time in 1924, Schmitt was truthfully ambivalent regarding Hindenburg's presidency. He shared the opinion of social democrats that Hindenburg was too old and therefore bordering senility. He wasn't fit for the task, and we couldn't expect from him nor from Ebert, because Ebert was social democrat, someone as important as the guardian of the Constitution. And then a word that is crucial throughout this essay, and I would argue Schmitt's writings, but that hasn't been addressed so far, is Sachlichkeit, matter of factness, or even materiality. And he has this whole argument about how measures ultimately pivot on their Sachlichkeit. And something that I have the feeling is that ultimately Schmidt would argue at that moment, before some changes in the power constellation that led military officers to the head of the Ministry of Defense. And I would even argue that Schmidt's change of view regarding Hindenburg is connected to these changes in the Ministry of Defense. But before that, at that time, his reasoning was the ultimate judge about the Sachlichkeit of the measures issued under Article 48 is not the president, but the military, because the military are the ones who are going to execute these measures. So then the second question is, considering these oscillations, how Professor Vinx sees the military and the role of the military in Schmidt's oscillating views on constitutional guardianship. And then to give further, in the same sense, further evidence about how this matters, beyond the fact that Schmidt changed positions to a less prestigious place so that he could be in close contact with the circles of power of the Weimar Republic and Hindenburg's presidency. Something that I found in Schmidt's diaries is that he was also in touch with Hans von Seeckt. And this is a name that I always pronounce incorrectly, and Germans always correct me. But nonetheless, he was, until 1927 or 28, the chief of the military in the Weimar Republic. And if not by Ebert's early death, Hans von Seeckt planned to be the military's presidential candidate instead of Hindenburg. And in Schmidt's diaries, we know that Schmidt sent Hans von Seeckt a copy of his Diktatur. And we also know that Schmidt attended many lectures gave by Hans von Seeckt from 1928-29 up to 1932, where Hans von Seeckt basically set the plan, the blueprint for the presidential cabinet. So for instance, you can, in his published book, Die Zukunft des Reiches, Urteile und Forderungen, Hans von Seeckt incorporates many passages in paraphrase from Schmidt's Die Diktatur. And this shows this connection otherwise unnoticed and unexplored by scholarship between Schmidt and a crucial figure in this military scene. So as I said, just a further evidence of why focusing on Schmidt's take on the military matters to how we assess his take on constitutional guardianship. And these were my two remarks and my more or less open questions to Professor Vinx. I hope that they are interesting and stir further discussion. Thank you very much.
Thank you, Ricardo.
Yes, so thanks so much for these questions. I think they're great. So I'm intrigued by this connection between von Seeckt and Schmidt. So that is very, very interesting indeed. So thanks for making me aware of that. So to the first question, so I think it's difficult to say who was the underdog in Weimar. So of course, Schmidt represented there's a movement in public law theory that wanted to get away from statutory positivism and from the formalist approach of old. And clearly, he was not the only person who was in that movement. So there are other authors like Smend, for instance, who are also banging that drum and who had some influence in the post-war Bundesrepublik. And clearly, if you look at the historical consequences of the debate, then Schmidt and his camp won. So they are seen as the people who influenced the future order in the post-war Bundesrepublik more so than the old statutory positivists. Now, when it comes to the situation in Weimar, I think it's not so clear because the old guard still has a great deal of influence. So people like Anschutz and Triepel, for instance. And one thing that I find quite interesting is that there's a stenographic report of the proceedings in Leipzig, where all these people, Schmidt and a number of other luminaries of public law theory, appear as legal representatives and argue the case for or against the federal government in court. And Anschutz, by the way, was one of the people who appeared for the government of Prussia, I think. And so if you look at these exchanges that they had in court, then it seems that Schmidt was really under pretty severe pressure, and that neither the court nor his colleagues really bought into his theory of dictatorship, and in the implications that the court perhaps might have drawn from it. So that suggests he was a bit of an underdog, perhaps. But you're right to say that I think I agree with this observation about Anschutz's commentary, that Anschutz is quite ambivalent. And so what he does in several places in that commentary is to refer to Schmidt's views and to say, well, no, this is not the law, but perhaps de lege ferenda, it's an interesting suggestion, and perhaps the constitution could be changed in that way. But it's not the law, okay? Because what the law is determined by a sort of formalist method of interpretation that he practices. And so it seems that for him, there's a distinction between these two questions, de lege lata, de lege ferenda. And his position to Schmidt differs depending on which of these two perspectives he adopts. Now to the second question, so in a sense, the president is the military, right? So even Hindenburg is, so because Hindenburg is a very, very old man, in the early 1930s, and there's a suspicion that he's a bit senile and not in the full possession of his mental powers, and that really it's people around him who whisper into his ear, who hold the real political power. And of course, von Schleicher was perhaps the most influential of them, together with the president's son, I think. And so in a sense, Schmidt perhaps advocates for presidential guardianship because he realized, well, ultimately it's the military that stands behind it, and that in a sense uses the president as a figurehead to procure political legitimacy for what is, in a sense, the military's project to reverse the constitutional change from a limited monarchy to a democratic republic. But of course, there's a problem, I think, in the German context with focusing on the military alone. So of course, if some institution is to play this role of guardian of the constitution or of sovereign, perhaps even, the people who lead it have to be willing to step up and take political responsibility and to say, the well-being of the nation is in our hands, and we are taking care of things. But the generals in the Reichswehr weren't willing to do that. And Schleicher himself seems to have had doubts about whether the Reichswehr would be able to prevail against communist militias or the Nazi stormtroopers and so on in a situation of civil war. And so in a sense, the military itself didn't want to take the final step, declaring itself to be sovereign. They needed this, the legitimating cover of presidential dictatorship, I guess, to pursue their project. And they didn't have the courage in the end to pull back the veil and to assume political responsibility. And so you can see the same thing there's a continuation to that in the Nazi period, where, of course, many of the generals are not great fans of National Socialism, and they realize Hitler is an idiot and he's going to destroy the country, but they can't, until very, very late, they can't decide to do anything about it, because they have this ethos that they're supposed to be servants of the government and not to take an openly political role. And so I guess there were, in a sense, cultural limitations, perhaps, to what the military could reasonably have done. I mean, as to Schmidt personally, of course, he was extremely ambitious. And I think you're right to say that he went to Berlin because he wanted to become involved in political affairs. And of course, his aspiration was then realized after the Nazi seizure of power, when he was finally appointed to a professorship at the University of Berlin. And for a while, at least, had a great deal of influence in legal academia. So he was clearly, as many biographers have pointed out, he was a very, very ambitious person who was perhaps willing to leave principle behind in order to secure personal advancement. Yeah, but thank you so much. I think
thank you. Thank you very much. Fascinating answers. I have nothing to add. And many cues for further research, not only by us, but by people in the audience. I would say.
Thank you, Ricardo. Now a question, Rodrigo.
Não quero segurar ninguém também. Não,
Não, quem quiser pode sair.
Não quero segurar ninguém. But I actually have two questions. I'll try to be quick. So the first question is that, according to one interpretation, it's not so much that the Article 48 provided what Schmidt said, but rather that Schmidt saw an opening in the Article 48 of the Weimar Constitution. And my question is that I agree with you in some sense that the article clearly does not provide everything that Schmidt wants to put in the Article 48, but rather that he's trying to put forth his views in political theology.
Yes.
And the second question that I want to say is more like a comment, and that in the sense that the ruling in Prussia contra Reich case, it's weird in the sense that's clearly not within the borders of interpretation, so to say, but it's not a manner unheard of in contemporary constitutional education. In the sense that, for example, the Supreme Court of Brazil gives rulings of interpretation within the Constitution that are allegedly, I don't speak German, so I can say, common in Germany, in the sense that, for example, I think in one state of Brazil, the police had like a quota of 10% for women, and it was clearly a maximum, but the Supreme Court went and say that it was to be read as a minimum. And the question would be, is there any way in which, according to Schmidt or Kelsen, this sort of ruling could be justified in the sense that courts are
Positive legislators.
Not only negative legislators, but also positive legislators. That would be my two questions that I'd like to get a comment, reply.
Right.
Whatever.
Yeah. So let me start with the first. So I think I agree with what you said about how Schmidt understands Article 48. And so I think I said at some point during the lecture that the people who hold this doctrine of inviolability, they claim that the Constitution confers the dictatorial powers on the president, and therefore the power must be considered to be limited by the Constitution. And I think Schmidt disagrees with that in a sense. So Schmidt thinks that, and that is the argument in political theology, I guess, that in any constitutional system or legal system, for it to work, there must be an institution that can take the sovereign decision on the exception in a situation of crisis. And I think the argument in political theology is not about any particular constitution or the powers it confers. It's a general political theoretical or legal theoretical argument that says that even if, say, you had a constitution that doesn't contain an article like Article 48, it has to be possible to identify someone who in a situation of crisis could step into the role of a sovereign if the system is to be considered as a stable, bona fide legal system. So the question is not whether there's a justification in positive law for what the president does, but whether the president can play this political role that is defined in political theology. And I think you're right to say that Article 48 is a kind of place where Schmidt thinks there's an opening to bring this wider political conception into the Constitution. Okay? But of course, you can only do that if you reject the idea that the Constitution must be read on its own terms. You must read the Constitution in light of this theory of the political that he developed throughout the 1920s, and that he thinks you have to then sort of somehow read into the Constitution. And so Article 48 is in kind of the entry point for that project. So yes, I think I agree with that. So politically, he in his view, it wouldn't really have mattered whether there was an article like that if say, the military, to go back to the other discussion, would have been more willing to openly assume dictatorial. Yeah, so the other question, remind me, what was the other question?
Of interpretation within the Constitution.
Yes. Well, I suppose the question is whether Kelsen and Schmidt are perhaps a little bit too harsh on the court. So I guess, of course, we read the court's judgment in hindsight. So we read it from the perspective that a few months later, the Nazis took power and then installed this extremely vicious, violent dictatorship. But of course, the path to power for Hitler was very contingent. So it could have, so if Hindenburg had just decided not to appoint him and to bite the bullet and dissolve parliament, perhaps that would have worked and the Nazis would never have taken power. So in fact, in the last free elections in the Weimar Republic in November 1932, I think, they already saw a very large diminution of their share in the vote. So Hitler was becoming less popular at the point. And so perhaps they could just waited for a few more months and the crisis would have passed. And then the court might have succeeded in saving federalism from the incursion of a unitary government. And perhaps in that case, we would applaud it as a shrewd and successful stratagem. Right? So, and perhaps as an instance of verfassungskonforme Auslegung. So basically an interpretation that tries to read this decree or a statute in such a way as to make it conformable to the Constitution. And yes, I mean, that is a common practice. And perhaps Kelsen is too harsh and Schmidt is too harsh. And perhaps the fact that things did play out differently on the historical plane doesn't really show that their assessments can't be challenged. So, I mean, I think that's a sympathy I have a certain, a perspective I have a certain sympathy for. There's an interesting author named Arnold Brecht who was one of the Prussian governments, or the Prussian government's lead representative in this trial, who wrote an interesting book, Prelude to Silence, where he gives his own account of how the Weimar Republic disintegrated. And so he has a much more favorable view of the court's judgment and thinks that it might have worked and they did what was possible at the time. So.
Thank you.
Please.
Thank you, Professor Vinx. I have a question about the United States situation. So Trump is known, has been known as someone that is against immigration and other fundamental rights that include in their constitution. So my question is, wouldn't it be necessary to have a constitutional guardianship besides the president, because he is one of the persons that is most known for being against rights there is in the Constitution. So I'm sorry, I'm just a little nervous. So wouldn't it be necessary to have this constitution guardianship to protect some fundamental rights that are in their constitution, according to Kelsen?
Yes. I think in the U.S., presumably the Supreme Court could play that role. So, of course, in the U.S., the Supreme Court, in a sense, usurped the power to exercise a form of constitutional guardianship very early on in the history of the Republic in 1803, I think. And so the Supreme Court could step into that role. But I think Kelsen would say that the system of guardianship that you have in the US is not as well developed as it should be, because the US, of course, the US Supreme Court only takes up constitutional issues if they come up through particular legal cases that work their way up through other courts, and can take a long time, therefore, for a constitutional question to be settled. And obviously, Kelsen's model of a constitutional court is a model where, say, parliamentary parties or perhaps even individuals can directly appeal to the Supreme Court so that it can take action very quickly and perhaps review statutes, for instance, or decrees before they even gain validity or before they are issued. And And so, of course, that is he would say, a better, a more effective form of protection. And of course, in the US, I don't know very much about the constitutional system of the US, but another worry would be that in the American system of presidentialism, that the president has so many powers that he can exercise without being controlled by Congress. That a lot of damage can be done, and the remedies may be very, very slow in coming. So I guess that's something to be worried about potentially.
Você? Ah, então, satisfeito? Bom, então.
Pretty good. Thank you, Ricardo, for being here with us virtually. Thank you, Professor Vinx, and thank you, Nicolas, for the inspiration for this year-long series of lectures. And thank you, Daniela, for helping to welcome Professor Vinx. And thank you, Rodrigo, and thank you, everyone who is until this time with us. Thank you, and see you tomorrow.